Right, this is case number 21-173-185. This is Franklin River Apartments LLC versus Chanel Smith. That is before the court, set on for unspecified hearing on today's date. Your appearance for Franklin River, please.
Good morning, Your Honor. Navjot Francis, P72322, on behalf of Plaintiff's Attorney of Record.
All right, thank you, Ms. Francis. Good morning to you. I'm looking for Chanel Smith at this time. Please say something if you're there.
Hi, I'm here.
All right, good morning, Ms. Smith. It looks like I set a hearing after I received something that was offered as a responsive pleading in this matter. I don't see that there has been an answer filed. It looks like there is something in the nature of a request to cease and desist, refusal to pay, that kind of thing. So Ms. Francis, update me at this time.
Your Honor, I did speak to the defendant today. She does not want to discuss any resolution. I think we figured this was set as a pretrial. I'm not sure, Judge. If there is no answer, then at this time we would request a default judgment.
Yeah, Ms. Smith, you have not filed an answer to the complaint, ma'am, and the time is expired for doing so. Why did you file an answer?
Well, I requested a validation of debt, and I never received the validation of debt. And as a consumer, I was invoking my right for cease and desist, all further collections on this account. And as the original creditor, I refuse to pay this alleged debt pursuant to 15 USC 1692G, with this is defamation of character. There's a $1,000 fine for each violation, according to that validation of debt.
Okay, that's a bunch of foolishness when you have a complaint filed against you. When you have a complaint filed against you, that means that someone is suing. You have to respond to the complaint that is filed against you in the time that's required by law. You can also assert certain debtor and creditor rights and that kind of thing in the context of filing your answer, your response. You have not chosen to do that. So all of the challenges or the issues that you are raising, those are issues that are not pertaining to this action because you have a lawsuit filed against you. If someone sends you a notice that they have a debt against you or someone send you a bill, you can certainly send that kind of stuff to them, asking for all kinds of things. Once somebody files a lawsuit against you, you got to answer the lawsuit. This is not responsive. This is not responsive in any way to the lawsuit that was filed against you in December of 2021. And now we're 6 months out. And you haven't responded to the complaint. So
yes, during that time,
go ahead. I'm listening to you, ma'am.
I'm sorry, Judge. Yes, during that time, I had lost my fiance and I was in between homes and jobs and those things. So my response to the letter, that's why I didn't receive my things on time. But that was my situation during the time. And, that's why I thought I could still, respond in the way that I respond with the cease and desist.
No, you can't do it that way. I certainly sympathize with you in the loss of someone dear and close to you. Those things are always significant, and you may very well be able to assert among your reasons why you didn't answer the complaint. You may be able to assert in writing that among other things that you want to raise. But right now, your case stands in default because you haven't responded to the complaint.
Yes, I did respond. Sorry, Judge. I did respond and letting them know that information of character was hindering me because it's on my credit, and that I never received the validation of debt once I did receive the lawsuit from the attorney.
Yeah, you haven't responded to the lawsuit. The law requires that you file an answer in order for you to have any position before this court. You have to file a legal document in response to the plaintiff's matter. and you haven't done that. That's why, when I say you have filed a response, that's what I mean. If you get sued,
Okay.
you got to file a response to that lawsuit. So you're in default in this case. You can certainly file a motion to set aside the default in this matter. When you choose to do that on the second floor of this building, you can set forth reasons why you did not respond in a timely manner to the complaint in this matter. And if those reasons are somehow fit within what the law requires that you show good cause for not responding, and that you show that you have a meritorious defense to the claim in order for you to get the default set aside. So you'll need to do that on the second floor regarding this matter. And I'll take a look at anything that you file to see whether or not it's a legal requirement that you show good cause and a meritorious defense. If you're able to show those two things, then the court will set aside the default in this matter. But you have to cross that hurdle because you haven't responded. It's been 6 months regarding this case. So the default will be entered on today's date. You have the right to file a motion to set it aside and to set forth your reasons as to why you believe the default should be set aside regarding this matter. All right, that is my determination in this matter. I do wish both sides well. Thank you.
Judge, I'm
Okay.
sorry, was it just a default or a default judgment?
The default is introduced, presented that to me. A judgment will be entered upon its present. I have received the application for default. The default is entered today, and upon presentment of a judgment, the court will enter judgment by default on the terms phrased in the complaint. So, good day.
Thank you.
Thank you.
Thank you. All right, do I have? I have a party straight ahead. Do I have a case number 12-113-514? This is DLG and Associates Incorporated versus Gerald Quickly. Anyone on the Zoom in regard to that particular matter?
Felicia Harris, sir, for VMX International, the employer.
All right, thank you. All right, and you're not an attorney, correct?
Correct.
All right, have you spoken with, let's see. I see there's a petition for show cause that was issued by this court. And I believe that this was presented by an attorney for your agency. Is that correct?
It was not. It was, we actually, this was delivered to us just 2 weeks ago. There to our new office. We never received a writ on this. This is a terminated employee with VMX. We never received the original writ or disclosure from them. We just received this motion of affidavit to appear 2 weeks ago. There was delivered to our new office. The first one, I'm assuming they have our old address on there. So I'm assuming that.
Let me stop you. And so the VMX, that's a corporate entity, correct?
Correct.
Yeah, and you're not a lawyer. You're going to need a lawyer to have anything to say about this. You can't
Okay.
speak on the corporate entity. Let me see if I have the other side on here. Do I
We're
have?
not, we're a small business, so not a large corporation. We're a small business. So we don't have quote unquote attorneys, so we'll have to hire one or whatever from that end of it, but we're a small business.
Yeah, and I understand that. Just the law
Okay.
does not, allow you to speak on behalf of the entity, whether it's small or large.
Okay.
Let me see if I have anybody for DLG and Associates Incorporated. DLG and Associates Incorporated. All right, so what I'm going to do, this is a petition to show cause, and I don't have the other side on this Zoom. I know this is set for 10:20 this morning, and we're past that time. So what I'm going to do is I'm going to give you another date. I'm going to notify them and see if they want to come back. Make sure that you bring in somebody, a lawyer, someone that can speak on behalf of the entity if it makes sense.
Okay.
You want it at the end of the month?
Yeah.
The 30th?
June 30th at 10 o'clock a.m. All right, so be back in the Zoom at
Okay.
on 10 o'clock a.m. All right, I wish you
Okay.
all good days.
Thank you.
Thank you.
Bye-bye.
Bye-bye. I'm coming to Gail Reed and Detectives in just a moment. Just one moment. All right, this is case number 21-240-690. This is Gail Reed versus Protective Windows and Doors. Matters before the court for review. On the previous occasion, the court set it up so that the parties could go and mediate this matter or try to resolve it outside of the actual hearing regarding this matter. Your appearance for strike that, let me hear from Ms. Reed, you the plaintiff in this matter. State your name for the record now.
Gail Reed, the plaintiff.
All right, thank you. For defendant in this matter.
Michael Norman, appearing on behalf of Protector,
All right, thank you, Mr. Norman.
75844.
All right, thank you, sir. Good morning to the two of you. Look like there are some technical difficulties with Mr. Norman. Mr. Norman, are you still there, sir?
Look like, oh, he's trying to come back.
Yeah. Mr. Norman, are you there?
Yes, I am. It looks like it disconnected me for a second, but I'm here.
Yeah, something happened. I did get your appearance on this record. So, Mr. Norman, if you will update me, what's the status of things at this point, sir?
I checked the Mission Tribunal website yesterday. Both sides accepted case evaluation. So we just need to satisfy the rule, Ms. Reed.
Yeah, you have bad connection problems there. Ms. Reed, tell me what has happened here. Hold on just a second, Mr. Norman. Let's see if I can get it out of Ms. Reed. Hold on, Ms. Reed. He's out again. Something is wrong with his connection, so just hold on.
I apologize, Your Honor, on the Oakland County Courthouse hearing in 15 minutes. Can you hear me now, Your Honor?
Let's see if Ms. Reed can tell me what the status is, because you're kind of breaking up, and then I'll let you fill in. Ms. Reed, what's the status here? What happened?
So both parties accepted the award granted by the mediation group. $500.
All right, so that means the case is resolved and both sides accepted. All right, so is that what happened, as you understand as well, Mr. Norman?
Yes, Your Honor. Hopefully you can hear me.
Yeah,
Yes.
I hear you. I do hear you. The screen is kind of frozen and all that, but I got you. All right, well, that resolves it. You know, I'm glad that you were able to get this this resolved. Mediation is strange sometimes, but at times it helps to get to it. So I'll sign an order dismissing the case upon satisfaction of the mediation termination. And I take it that means that $500 is to be sent to Ms. Reed. That the way it meant?
Yes, and I did send her an email requesting the address, so if she just confirms the address she wants that sent to, we'll get that out immediately.
What email address did you use? Because when we spoke on the phone, you said you didn't have my email. So I need to make sure that you have the correct email address.
So
Is that something that should be shared on this Zoom?
No. That's what I was going to tell you. Why don't you put that in the chat? You know how to chat it, Ms. Reed?
I see chat here.
You see how to do that?
Yes.
Okay. Yeah, and I saw it come up. Mr. Norman, you got it, sir?
Sir, thank you, Your Honor.
All right. And so you guys should be able to communicate from there. And I'm going to go ahead and dismiss the matter with a contingency, and that is it'll be dismissed contingent upon the payment and the contingent upon the payment being made. If for some reason Ms. Reed doesn't get her money, then the case can be automatically reinstated.
How soon should I expect payment? Is there a stipulation as to when the defendant, the time frame the defendant should be rendering the payment?
Mr. Norman, how soon can we get this done?
We're gonna mail it within 7 days. So she should have it within 7 to 10 days.
Yeah. All right.
And if I may ask, what are you going to email again? What should I be
I just
expecting?
wanted you to, I sent you an email requesting that you confirm the mailing address.
Okay, will you send it? You're going to resend it to the email that I provided in chat today?
Yes,
Or at least, okay.
yes.
All right, yeah, so you should get it worked out. Ms. Reed, if for some reason, this falls into the cracks or something, then on any given day, just zoom in at my Zoom address and just let me know that you did get the money, and I'll get a hold of Mr. Norman and we'll come back together and figure out what we want. Okay?
That if I do not get it within a reasonable time, you said?
Yeah.
Okay.
I mean,
Yes,
I would give it 10 days, but 14 days, given some of the mail issues that we have, we're looking at 2 weeks, 14 days from now. And if you haven't received it by that time, you could reach out to Mr. Norman, or you could come back in the Zoom and say, Judge, I know we're trying to get this done, but something happened. And I'll get a hold of Mr. Norman, and we'll get him in and we'll figure out what.
Thank you, Your Honor. Yes, sir.
Thank you, Mr. Norman. Good
Thank you,
day to
Honor. Sorry.
I do
You
wish
too.
you well.
Sorry about the connection issue.
I wish you could
Thank
see
you.
on
You
this
as well.
side of it. If you could see on this side of it, have a little bit of humor. Seeing
I'm
this-
sorry, I'm in Oakland County.
Yeah, gotcha. All right, Ms. Reed, it's been a pleasure. Good day to the two.
Thank you. I appreciate it, Your Honor. Bye-bye.